morning, Mr. Coleman. Good morning. You're Valerie Hale. And will your client waive the formal reading of the indictment?
I don't think I put on the paperwork an interlock judge, but it's part of the agreement.
Okay. All right, Ms. Hale, in cause number 25 DCCR 0573, you're charged with the state jail felony offense of driving while intoxicated with a child under 15, and that's from March 13th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 2-year term in the state jail prison, but that would be probated. You'd be on probation for 5 years. Order to pay a $1,000 fine and to follow all of the rules and conditions of probation, including having an auto ignition interlock device on your vehicle. Do you understand? Do you have one now?
Yes.
Okay, I was about to say you should already have one. And so that'll be part of your probation, at least for some amount of time as well. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Hale's not competent?
There you go. We'll waive it, yes.
What kind of history, if any?
Absolutely none, Judge.
Okay.
Just go to my file.
All right. So, Ms. Hale, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Waive the pre-sentence report, find sufficient evidence to find you guilty, and at this time follow the agreement that you made with the district attorney and find you guilty of driving while intoxicated with a child passenger. Sentence you in accordance with that agreement to a term of 2 years in the state jail prison, but I'm going to probate that. You'll be on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and condition of probation, including continuing with that interlock device until further order of the court. Okay. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. And so this is for you, for this probation, this is for all practical purposes, your case here in court is over, and you'll be able to serve that 2 years while you're out on probation instead of in the state jail prison. And if you do everything correctly, you'll never be back in court. The other side of that, though, is if you violate any condition of probation, you can be brought back into court and you could be facing that 2-year sentence that you've agreed to. Do you understand? All right. You just need to have a seat here in the courtroom. Probation, she's in at that desk right there. She's going to call you up when she's ready to go over your paperwork. Okay? Yes, ma'am. Good luck. At least I'm making us younger, not up there. Like I said, I've got already. What is this? Hers.
I'm going to take care of
All right, ma'am. Good morning. Are you Melissa Taylor?
Yes, ma'am.
And will your client waive the formal reading of the indictment in each case?
So wait.
I'm going to take judicial notice of the court's file. Ms. Taylor was evaluated for competency to stand trial. Dr. Kraphan did that evaluation. I've received the report dated May 22nd of 2025 with the finding from Dr. Kraphan that Ms. Taylor is currently competent to stand trial. Is there any other evidence with regard to competency?
Your Honor, I can only say that I've visited with her a couple of times out at the jail again this morning, and I believe that she's mentally competent.
All right.
I can't say that there's no evidence of mental incompetency because I think that there was at one time the evidence, but there's none that I've observed that would lead you to she's currently mentally incompetent.
All right. And Mr. Nichols?
Nothing to add, Your Honor.
All right. Then based on the report and Mr. Kimmler's comments, I am going to find Ms. Taylor currently competent to stand trial. Now, Ms. Taylor, in cause number 24 DCCR 2177, you're charged with second-degree felony offense of assault on a peace officer from October 2nd of 2024. And how do you plead to that charge?
Yeah.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
That would be correct. Yes.
All right. And in cause number 24 DCCR 2311, you're charged with the state jail felony offense of credit or debit card abuse from October 2nd of 2024. And how do you plead to that charge?
I'm guilty.
Again, are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
I did.
Do you fully understand that?
Yes, ma'am, I do.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a cap of 5 years in the assault on a peace officer case. And then whatever happens, I guess you're pleading open on the other one as long as I run them
I made a
concurrently.
recommendation for 12 months on that
Okay,
case,
12.
Your Honor, and the defense had made a recommendation for probation and concurrent with this one day.
Okay, so in essence, a cap of 12 months then? Would
Yes,
that,
Your Honor, that's fair to say.
It concurrent.
with everyone's permission,
Yes.
can I make that? Let's see. Cap. So it would be a cap of 12 months on that state jail case. Do you understand?
Yes, ma'am. And that's for the
No, it's
No, it's for a credit card.
credit card.
Yeah.
So what that means is that if we go forward this way, you're leaving your punishment up to me.
Okay.
And as long as I don't give you more than 5 years in the assault on a peace officer case and 12 months on the credit debit card abuse case, then you're waiving your right to appeal. I can give you 5 years. I can give you less. It'll all be determined when I get the information at a sentencing hearing. You have an absolute right to have a jury come in and determine 2 things. The first would be to decide if you're guilty or not. And then if they find you guilty, you could leave your punishment up to them. If we go forward this way, you're waiving that right and leaving it up to me with those ranges that you've agreed to. Is that what you want to do?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1 in each case.
Without objection.
It's admitted in each case. All right, ma'am, I'm going to find that you entered your pleas of guilty in each case freely and voluntarily. Again, find that you're mentally competent and understand the nature and the consequences of your pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases so that the probation department can do a precedence report. That'll give me more information about you, your cases, and then we will cut back later for sentencing. Anything that you think is important for me to know, be sure and get that information to Mr. Kimler. He'll present it to me on your behalf when we come back.
Okay.
All right.
And I do have a support letter that I tendered to the court.
If you'll just get that to the clerk, please. All right. Thank you, ma'am. You can go back with the bailiff. Good morning. Are you Christopher Morrell?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment? Mr. Morrell, in cause number 25, DCCR 0466, you're charged with the third-degree felony offense of continuous violence against the family from February 8th of 2025. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes.
And because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes, ma'am, I did.
And do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation, including entering and successfully completing an anger management program. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenors number 1.
No objection.
It's admitted. Is there any evidence that Mr. Morale is not competent?
Negative.
And as a condition of your bond, is it already, you should already have a condition that you're not to have any contact at all with Alonda Kelly?
Yes, ma'am.
Okay. So I want to make sure that you're still under that bond condition, that it will likely be a condition of your probation as well.
Absolutely.
So I want to, if you violate that and have any contact or communication with her whatsoever before sentencing, then I don't have to accept this agreement. Things could be much worse. Do you understand?
Yes, ma'am.
All right. So I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there. All right, we'll see you back at sentencing.
Yes.
Thank you, Mr. Parker. When did you smoke marijuana last? So here's the thing. You need to tell me the truth, because I'm going to get a quantity amount, not just that you're positive, but I'm going to get how much is in your system. And so I need to know when you smoked it last, so that if I find out next time it's not going down, things are going to be worse. So when did you smoke? When did you smoke last? Day before yesterday. So that's why you weren't wearing your patch.
No, really, I just, like I said, I'm on 2 different levels. I was already done doing my first one.
Right.
Now I'm on the second one. The first one, when I was on, that's when my blood pressure. I figured since I was in pain, everybody know I had to return first. They hadn't me out of
I know that'd be really convenient if you had 2 felonies and you didn't have to wear a drug patch and you could smoke marijuana 2 days before court. That'd be pretty convenient, wouldn't it? So you're going to have a drug patch today within 24 hours. I know the first one will be positive, obviously. If the next one is not going down, then your bonds in each of your cases will be raised and you will be back in custody. No questions asked. Do you understand? So you have 24 hours. I want you to get confirmation of that to your bondsman. Even though you've paid your bondsman, they're still your bondsman. They're still going to give you, just because you paid them off doesn't mean they're not your bondsman anymore. Okay, so even if you pay off the other one, you're still out on bond. You're still required to keep in touch with them. They're the ones who'll help you figure out when your court days and all of that stuff. So don't stop communicating with them, because even though you've paid them, they can get off your bond and you can go back to jail. So keep up with everything you're supposed to. I want proof to them by tomorrow or this afternoon that you have the drug patch. You need to make sure it's switched every 2 weeks like it's supposed to. Wear it properly. There's no going in and saying, well, it fell off, and none of that.
I'm 18 I was on good, but I ain't never feel no good.
Okay. Well, that makes me more concerned about your decision making if you were doing well and then you decided right before court to go smoke, right? Okay. Step in front of the clerk. She's going to give you a reset notice. You need to get a lawyer hired as well before that.